Good afternoon, everyone. This is Kelly Larson from the Land Remediation section at the Ministry of Environment. I'm a senior policy analyst with the group, and I'll be presenting this webinar on the CSR Stage 13 amendment implementation. I'd also just wanted to quickly introduce Valentina Yetzcalo is on the line. She's the Manager of Operations and Policy Unit, and Danielle Gerbevats, who's the Director of the Land Remediation section. A few things about the webinar format. I will give a approximately 35-minute PowerPoint presentation. I'll stop just about halfway to just pause and see if there's any questions up to that point or if anyone needs any clarification, and then there should be plenty of time at the end for Q&As. We have quite a few people on the line, so I will try and get to everyone's questions within the time period. All of your mics are muted for this session. If you want to ask a question, use the question box at the bottom of the GoToWebinar panel on the right-hand side of your screen. The questions will be answered in the order that they're received. Okay. So before I begin, I'd like to acknowledge the unceded traditional territory of the Coquitlam First Nation, where I live, work, and play. The name Coquitlam means red fish up the river in their traditional language of Halkomelem. The nation is traditionally a fishing community along the Fraser River, and many members carry this on today. So today's webinar will focus on the various aspects of the provincial site identification process. I will explain what site identification is, what is changing, and provide step-by-step detailed information about the process. In the context of EMA and the CSR, the term municipality includes regional districts and the Islands Trust. And for the purposes of this webinar, I'm also referring to approving officers and modern treaty nations that use the site identification process when I use the term municipality. I wanted to bring your attention to the email address on the screen at siteid with a capital ID at gov.bc.ca. This email is specific to supporting implementation of the amendments, so please continue using the site profiles at gov.bc.ca email address for submitting site profiles until February the 1st. If at the end of the hour there are still some questions I wasn't able to get to, you can forward your questions to this email address and I will answer them as soon as possible. So what is the site identification process? It brings sites to the attention of the ministry to ensure investigation and remediation of contaminated sites occurs prior to redevelopment for the protection of human health and the environment. It applies to sites where specific industrial and commercial activities have occurred, and it is initiated when an industrial or commercial activity stops or when a site is being redeveloped and requires approvals from a municipality. It's a significant entry point into contaminated sites processes. Go on here. The legal provisions are legislated by Environmental Management Act and the Contaminated Sites Regulation. And there are also similar provisions in the Local Government Act, the Land Title Act, the Islands Trust Act, and the Vancouver Charter that further lay out the role of municipalities in this process. The municipal statutes state that the approving authority must not approve applications specified in EMA under certain circumstances. The majority of sites that are identified through this process are typically through the municipal permitting triggers, and this is a flow chart that highlights the framework of that particular part of the site identification process. The red lettering in each box is where there have been amendments to the existing process that come into effect in February of 2021. I'm just going to go through this flow chart really quickly, and then we'll go through each individual step in much more detail throughout the rest of the presentation. So starting from the top left-hand corner, If a municipality or approving officer receives a subdivision, zoning, building, or development permit application for a commercial or industrial property, you have to determine, or the property owner has to determine, if there was a Schedule 2 activity on the site. If there wasn't, then there are no restrictions on application approvals. If there are Schedule 2 activities on the site, the next step is to determine if there's any exemptions from the site identification process. If an exemption applies, then again, there are no restrictions on approving that application. If no exemptions apply, the applicant has to fill out what's called a site disclosure statement. That site disclosure statement is provided to the municipality along with their application. And the municipality reviews the form for completeness, and they submit the form to the site registrar at the Ministry of Environment. Doing so triggers a requirement for site investigation, and those applications cannot be approved. So the next step is for the owner to get their permits approved is to obtain one of the following: either a certificate of compliance, an approval in principle of a remediation plan, a determination the site's not contaminated, or a release notice from the director. Any one of those 4 things will remove restrictions that are on the applications to get them approved through the municipality. So amendments to the site identification provisions in EMA and the CSR have been approved and come into effect on February the 1st of 2021. Bill 17, which is amendments to EMA, can be viewed in full on the Legislative Assembly webpage, and the Order in Council for the Contaminated Sites Regulation amendments can be viewed on the BC Laws webpage. And those links were provided in the on the registration page for this webinar. Significant changes were made to EMA to improve the site identification requirements. The site profile is renamed to a site disclosure statement to more accurately reflect the type of information being provided to the ministry. Definitions were clarified, and a new definition was added for specified industrial or commercial use to highlight the connection between requirements of EMA and the requirements in CSR. The conditions for submitting a site disclosure statement for industrial and commercial uses are simplified. These conditions include site closure, insolvency proceedings, and applications for subdivision, zoning, and development or building permits that will likely disturb soil. The director will no longer be required to review a site disclosure statement. New requirements are introduced that specify every person who is required to provide a site disclosure statement must complete site investigation and submit information in accordance with the regulations. All of the exemptions that are currently included in EMA were repealed. All of the exemptions to the site identification process are now found in the CSR. The requirements for sites regulated under the Oil and Gas Activities Act and associated regulations were revised, recognizing that the Oil and Gas Commission is responsible for the management of oil and gas sites, including remediation of those sites under those separate legislation and regulations. Because of that, the Commission no longer has responsibilities for site identification. In the case of decommissioning or ceasing operations, a site disclosure statement must be submitted to the site registrar, and a copy of that site disclosure statement would be sent to the Commission instead. Consequential amendments were also made to other statutes like the Local Government Act and the Vancouver Charter to ensure they align with the changes that were made to EMA. So changes to the Contaminated Sites Regulation were made to reflect and build upon those made to EMA under Bill 17. A new site disclosure statement will replace the site profile form that's currently found in Schedule 1 of the CSR. Similar to the current form, the site disclosure statement will require specific information about ownership, site location details, and current and historical use. However, the yes or no questions that are on the current form have been removed from the site disclosure statement. Site disclosure statements submitted in connection with municipal applications will continue to be submitted to the approving authority first, which will then be forwarded to the site registrar instead of the director. Changes to Schedule 2 improve clarity, reduce redundancy, and provide exclusions in some instances. The updates also include additional purposes and activities to address situations where potentially contaminated sites are not currently being captured. An example of this is fire training facilities. All of the exemptions in Section 4 of the CSR have been revised and some new exemptions added to improve clarity and applicability and to ensure the site identification process only captures sites that decommission or cease operations, are being redeveloped for a new use, or are undergoing a significant upgrade to an existing Schedule 2 use. Municipalities will no longer be able to opt out of the site identification process to ensure a consistent, provincially run process for identifying contaminated sites. And in addition to the EMA amendments that impose an automatic requirement for site investigation in cases where a site disclosure statement is required, the CSR sets out requirements for the types of investigation to be completed, timing for completion, and reporting. So this is where we're going to start going into more detail on each of the aspects of this process. I think this is probably a good time to take a quick break and see if there's any questions up to this point.
Thanks, Kelly. We don't have any questions that have come in at this point.
Okay, perfect. Then I will just keep on going. All right, so shutdown and insolvency triggers. Sites that shut down, either purposefully or due to insolvency proceedings, are subject to the site identification process. The existing definition for decommissioning a site has been revised and expanded to include ceasing operations. So I'll just go through the definitions quickly. An owner or operator decommissions a site if they do any of the following actions designed to stop all specified industrial or commercial uses of the site. A, they either remove or treat soil, or B, they remove, destroy, or treat buildings or process equipment, including storage tanks. For ceasing operations, an owner or operator ceases operation on land if the land stops being used for a specified industrial or commercial use for a period of 12 months. A site disclosure statement must be submitted to the director within 6 months of decommissioning a site or ceasing operations. Other insolvency proceedings include foreclosure or filing proceedings under the Companies Creditors Arrangement Act or the Bankruptcy and Insolvency Act. In foreclosure, a site disclosure statement must be submitted to the site registrar within 10 days after the person takes possession or control of the site. And for the CCAA or BIA proceedings, a site disclosure statement must be submitted to the registrar within 90 days of filing those proceedings. The municipal triggers for site identification. Municipal applications that trigger site identification processes include subdivision, and that is also including areas where the Ministry of Transportation and Infrastructure is the approving officer, zoning, and development permits and building permits where soil disturbance is likely. There's no specified amount of what soil disturbance means. It is any soil disturbance that would trigger that permit. It would not apply to permits for interior renovations of an existing building because there would be no soil disturbance, or exterior if someone needed a building permit to replace a roof or something like that. But it would apply to additions to buildings. Just a note that we've removed demolition, development variance permits, and soil removal triggers as part of the amendments. There is a real estate trigger. So a vendor of a property that was used for a specified industrial or commercial use must provide a site disclosure statement to a prospective purchaser at least 30 days before the actual transfer of the property. This site disclosure statement is not forwarded to the site registrar and does not initiate requirements for site investigation. It is for disclosure purposes only between the vendor and the purchaser. So what are the specified industrial commercial uses? Schedule 2 of the CSR lists all of the industrial and commercial uses that are impacted by the site identification process. If the use is not listed in Schedule 2, then site identification is not applicable to the site. The uses are specific to industrial and commercial scale activities, not agricultural or residential. This is not related to municipal zoning, but actual land use. For example, a farm may have a fuel storage tank for their farm equipment, but this does not constitute a Schedule 2 use, which might be F5, petroleum dispensing facilities, as this is not relating to industrial or commercial use. Alternatively, if a person operates an auto repair business out of their garage, that would be considered G2 vehicle repair, salvaging, or wrecking, because it is a commercial business, even though it's happening on their residential property. The terms shipping and handling have been added to many of the uses listed in the schedule. Just wanted to note that these terms are not intended to apply to retail stores or for private uses. I mentioned already that new uses have been added, such as fire training facilities. Many other uses have been clarified. For example, it has been clarified that migration of contamination from a residential property to another residential property is not a Schedule 2 use. Also, any outdoor firearm shooting range is a Schedule 2 use, not just rifle ranges. These are just a few examples of some of the activities that have been revised. Exemptions from site identification process. So even if a site has a Schedule 2 use, an application may be exempt from the process in specific instances. Section 4 of the CSR lists many different exemptions that may apply to a municipal application. Some examples include if the owner can provide a valid certificate of compliance, approval in principle, determination the site is not contaminated, or if the site is within an environmental management area, those are exemptions from the process. For subdivision, if the application is for an adjustment to the boundary of a parcel or consolidation of 2 or more parcels into a single parcel, is a new exemption being added. For zoning, if the Schedule 2 activity will continue at the site, but a zoning amendment is required. And for building and development permits, there are exemptions for demolition or minor works such as installing or replacing underground utilities, installing or replacing fencing or signage, paving or landscaping. That's also a new exemption that's been added. One other thing, there is a provision in the Local Government Act and the Vancouver Charter and the Islands Trust Act that allows an approving authority to approve a zoning application if they have also received an application for either a development or a building permit for the same development project. This allows the municipality to continue with their processes while ensuring that site investigation is completed prior to the next set of permit approvals, meaning that the development permit or the building permit cannot be approved until ministry requirements are met in that situation. Site disclosure statements. They are a form that is about 4 pages long, has 5 sections, and the sections are this. There's contact information. This can be completed by a designated agent, but the form must be signed by the owner or operator as the person with the most knowledge of the site. There's a section for site information, including latitude and longitude, the civic address, if there is one, parcel identifier numbers associated with the site, and a site map. It's only required to include the parcel identifier numbers where the Schedule 2 activity actually occurred, not necessarily all of the parcels that are included in a specific application. There's a section for identifying the specified and industrial commercial uses that are listed in Schedule 2 that apply to the site. The applicant must fill in both the category and the number reference from Schedule 2 into this section. There's a section for additional information, which includes a summary of planned development or proposed land use, and a list of the resources that were used to complete the form. For example, what historical searches were completed. The ministry will be providing guidance on our webpage on where to find information on historical site use. And the last section is for declarations, where the owner or the operator must sign the form and identify if any exemptions in the section 4 of the CSR apply. There is also a section that the approving authority will fill out, the municipality will fill out, that must be completed before it's forwarded to the site registrar, and that includes checking off the reason for submission, so which permit was applied for that triggered the site identification process. The municipality has a role in the site identification, and it revolves around receiving, assessing, and forwarding a site disclosure statement. Municipalities must complete their role within 15 days of receiving the site disclosure statement. Site disclosure statements that note at least one Schedule 2 use must be forwarded to the site registrar. Doing so initiates requirements for the owner or operator to complete site investigation. Municipal applications cannot be approved until certain conditions are met. And I'll have a slide later on that just describes those conditions. Municipalities can ask applicants to complete the form even if there is no Schedule 2 use at the site, and that is so they can keep that information for their internal records. Site investigation and reporting. New requirements for site investigation and reporting are triggered in the CSR in certain instances when a site disclosure statement is submitted to the site registrar. Those are for release notices. Prior to requesting a release notice from the director using the independent remediation clause in the municipal statutes, which is now what we know as scenario 4 and 5 in Administrative Guidance 6. Before you can request one of those releases, site investigation must be completed, starting with a preliminary site investigation, followed by a detailed site investigation if contamination is identified. Reports of those investigations must meet requirements set out in the CSR sections 58 and 59 for those types of reports, and they must be submitted with the release request. The director can also request additional information relating to the release notice. For decommissioning, CC operations, and foreclosure, site investigations must be completed within 1 year of submitting a site disclosure statement. This includes a detailed site investigation if contamination is identified, and Protocol 12 will be revised to include these requirements as a trigger for completing a site risk classification report. This is how we are currently doing things right now. It has just been written into the contaminated sites regulation as requirements instead of us doing it by policy right now. These requirements do not apply to waste management facilities that are under an active permit or operational certificate, or for sites that are considered operating areas under the Oil and Gas Activities Act. Insolvent owners that are under CCAA or BIA proceedings must submit existing environmental reports for the sites that were produced in the previous 5 years. Those reports must be provided to the director within 30 days of submitting a site disclosure statement. Submission of a site disclosure statement that indicates a Schedule 2 use triggers a prohibition in the Local Government Act, Islands Trust Act, Land Title Act, and Vancouver Charter, where approving authorities must not approve the triggering application until the applicant meets ministry requirements by obtaining a ministry certification document that is valid and subsisting for the proposed use at the site. You cannot apply for any of these documents without first completing site investigation. These documents include certificates of compliance. These are issued when a contaminated site is remediated to meet a certain land use standard. When a site is remediated using risk assessment, it's the owner's responsibility to provide confirmation to the municipality, likely in the form of a letter from a qualified professional, that the proposed land use meets the conditions of the certificate. You could also obtain an approval in principle of a remediation plan to get your permits approved. This is where the ministry has approved the remediation plan for a site. The ministry can impose conditions in the AIP, and they can also approve certain waste discharges to the environment in that AIP. The other option is to get a determination the site is not contaminated. This is issued for sites that have been fully investigated and no contamination was ever identified. And the fourth option is release notices that are also an option for removing the prohibition on approving municipal applications. The director can issue several different types of release notices depending on the situation. For example, the director may indicate that the site investigation is not required prior to approval of a specific application, or that an application can be approved because the site presents no significant risk or threat if that application were approved, or that an application can be approved because the applicant intends to complete independent remediation during development. Release notices are for a one-time use only and only apply to the applications specified in the letter. They are considered invalid if any conditions imposed by the director are not complied with. The next couple of slides go into a bit more detail about the effect of Stage 13 amendments on release notices. So Administrative Guidance 6 currently describes the different types of release notices and expectations for submitting release requests. Amendments to EMA and the CSR, such as changes to the triggers for submitting a site disclosure statement, new exemptions, site investigation and reporting requirements, and other policy changes will affect how release notices are issued. I have a few examples of how. Part 1 of Admin Guidance 6 talks about no site investigation required decisions. That part is going to be removed. So if site investigation has been completed at the site at the time of submitting the site disclosure statement, the application can proceed with one of the options for release notices or make an application for a ministry certification document, such as a certificate of compliance. For scenarios 1 and 2, those currently account for about 50% of all of the release notices that are issued by the director. Scenario 1 is for demolition. It will no longer be required because demolition will not be a trigger for submitting a site disclosure statement. And for scenario 2, the need for those will be minimized because of, mainly because of the new exemptions that have been brought into the CSR. Scenario 2 is typically used for preliminary approvals that lead up to redevelopment of a site, things like subdivision and zoning, or for minor site upgrades to an existing Schedule 2 use. So there's new exemptions for zoning where a Schedule 2 activity will continue and you just need to rezone for some reason. Maybe they're putting in a car wash or something like that that wasn't there before and they needed a text amendment. That is now an exemption. And I mentioned before about subdivision for boundary adjustments and for minor development in certain circumstances. I mentioned that as well for minor works like utilities and paving and landscaping and things like that. Scenario 3, that is a very rare occurrence currently, and it will be removed because there are other options to obtain permits should this unlikely situation occur. So that leaves scenario 2, 4, and 5, and which is odd to leave them numbered like that. So we will be renumbering the remaining scenario types into 1, 2, and 3. So it just makes a little more sense. So for scenarios 4 and 5, these release notices are meant to allow applicants to complete remediation at the same time as redeveloping a site. A release notice issued for this purpose is based on the provision in the municipal statutes that the director has received a remediation plan supporting independent remediation of the site. Now that's new wording. It's important wording. This provision highlights 2 facts. It cannot be used for sites that are not contaminated. An alternative is to obtain a determination. A remediation plan is defined by the CSR and it must be submitted to the director as part of the release request submission. There are new requirements in the CSR for site investigation and reporting related to release notices that I mentioned in the previous slide. A preliminary site investigation must be completed, followed by the detailed site investigation if a contamination is identified. And those reports describing the investigations must be submitted to the director as part of the release request. The ministry will no longer issue release notices for sites classified as high risk. Once the high risk conditions are remediated, a release request will be considered. Also, release notices will not be issued for multi-phase developments. So that means a site that will be developed in stages and requires many municipal approvals over multiple years. That's what we mean by multi-phase developments. For this type of situation, the ministry recommends obtaining an approval in principle or other ministry certification to proceed with development. Really, the release process is meant for simple, straightforward sites, not super complex, dragging out over multiple years type of redevelopments. So just keep that in mind. So I just wanted to throw this flow chart back up here again, since we've gone through each kind of box in detail, and maybe it will make a bit more sense now. You have a trigger that brings the site into the site identification process. If it has a schedule to activity, applications can be restricted if there aren't any exemptions that apply to the site. Site disclosure statements are forwarded to the site registrar. That triggers requirements for site investigation. And applicants have options for getting their permits approved. Those are obtaining certificates of compliance, approval in principles, determinations, or release notices to take the restrictions off their permit approvals. So transitional provisions. Bill 17 includes transitional provisions to assist municipalities in determining how to apply the new requirements. Just as an example, if the municipality receives an application, a complete application, before February 1st of 2021, the current site profile requirements will apply to that application until it's approved. If an application is received by the municipality after February 1st, the new requirements would apply. For opted out communities, complete applications received before February 1st of 2021 will not be subject to any site identification requirements because they're currently opted out. But any new applications, even if they're related to the same development project at a site, will be subject to the new requirements. There is also an exemption in the CSR for sites where a site profile has been completed for a site that had all no's marked on it. So it was forwarded to the site registrar, meaning that there's no outstanding requirements for site investigation under the current legal regime. These types of sites are exempted from the future site identification process. And then lastly, release requests that are received by the ministry up to January 31st at 5 p.m. will be processed under the current AG6 provisions. The caveat to that is the release request must be complete. It has to include all of the parts that are necessary components of a release request as described by Admin Guidance 6. And then anything received after February 1st or on February 1st and beyond will be subject to the new requirements. So implementation of the amendments is well underway. We've been busy working on updating our website. Approximately 40 fact sheets, guidance, and procedure documents were selected for review. The relevant content from these documents is being incorporated into new web pages. This includes 12 documents relating specifically to site identification that are being combined to create a comprehensive web page with useful information on how the process works, how to complete a site disclosure statement, and how to submit a release request. There will also be a page specific to municipalities and approving officers on how to complete their specific roles with assessing and forwarding site disclosure statements. We're also updating a number of protocols that will be released for comment soon. There's a new site disclosure statement, obviously, but also some of the other forms, we're making very minor updates to the fillable forms. And a few weeks ago, I also held meetings with many of the opted out communities to ensure that they are aware of and understand the upcoming changes. And finally, the intention is to seek stakeholder feedback after implementation is complete to evaluate the effectiveness of the amendments and the implementation plan. And lastly, just a reminder to sign up for Site Remediation News, which is our email service, so you can keep on top of new and exciting things happening in contaminated sites in BC. The protocols that we are posting for comment, you'll get a message about that when they are posted. And also these webinar recordings or possibly just the slides itself will be posted through this service. And that's the end of my talk here. So I think we should have plenty of time for questions.
Thanks, Kelly. We do have quite a few questions in the lineup. Our first one this afternoon is, if a site disclosure statement accompanies a municipal application and triggers the need for a site investigation, can the municipality process the application but not issue final approval, or must the municipality await environment's go ahead to process the application?
Hang on a second. I'm just trying to open this up so I can read it myself. It's just freezing on me. One moment, please. Okay, it's not liking that. The municipality can process the application as far along as they want to. They just cannot issue the final approval until they have received one of those documents that's listed in the municipal statutes, which is the certificate of compliance and approval in principle, a determination, or some type of release notice from the director.
Okay. So our next question comes from Ruby, and Ruby would like you to clarify the change for fire training sites.
Well, the change is that they're currently not included in Schedule 2, and they will be included in the future version of Schedule 2, and that has to do with some emerging contaminants that we're finding out about. I can't remember, I know the acronym, but I can't remember the full name of them, the PFAS and those types of chemicals. That's why we're adding fire training sites.
Okay, and a question from Michael. What are the new Schedule 2 uses? Have any been removed?
Some have been removed. I can't name them all off the top of my head. You'd have to look through Schedule 2 and see what the changes are. There is one for spills that currently in the site profile form, in the questions part, the yes/no questions part, there's a question about whether a spill has occurred on a site that was reported under the spill reporting regulation. Since we took those questions out of the site disclosure statement, we added a new Schedule 2 activity regarding spills, cumulative spills under the spill reporting regulation. So that's another one that was added.
Okay.
And there was one that was, the one on the top of my head I can think of that was removed was sawmills. The sawmills of themselves are not generally an issue. It's other activities that may happen on sawmills, but they are captured under other Schedule 2 activities like fuel storage and things like that. And then some activities were removed only because they were captured multiple times in the schedule. So we did a bit of cleanup in that regard.
Okay, our next question is from Marian. How is contaminant migration for off-site covered by the site disclosure process?
Contaminant migration from a commercial and industrial property to another property is still a Schedule 2 use E10. We just clarified that it was not residential contamination migration to another residential property. It's migration from an industrial commercial use, because the purpose of this process is to capture industrial commercial contaminated sites.
Okay, and our next question, will the site disclosure statement submission apply to properties where operations ceased long before February the 1st, 2021?
No. So these are effective as of February 1st, 2021. The
Okay.
timelines for what those definitions begins February 1st, 2021.
Okay, and is a site disclosure statement only triggered by current Schedule 2 uses or current and former Schedule 2 uses?
That hasn't changed, so it's current and former uses.
Okay, and next question is it an amount of fertilizer storage that triggers a location to become a site?
I don't believe it specifies an amount. I think it might say bulk fertilizer storage. Off the top of my head, I don't believe it has an amount stated.
Okay. Okay, and our next question, how will environment impose or enforce a review deadline on municipal handling of site disclosure forms?
To be honest, it is something that would probably just come to our attention if an applicant were to come to us and put in a complaint.
Okay, and we have a specific question here that's come from Trevor. We have a site where we're working through an AG6 Scenario 3 release. What replaces this? Site activity will continue. No contamination has been found at the site. Subdivision is planned.
The other scenarios would apply potentially, because potentially scenario 2 might work in that situation, depending on the circumstances of the site. I don't know enough about the site. That's something that Trevor's going to probably have to just contact the ministry specifically and see if he can get more information about how this would apply, because we need to know a bit more information to give an answer to that.
Okay, and our next question. Do I understand that once the site disclosure statement with the Schedule 2 activity has been identified, you have 1 year to complete the investigation? And if so, what is your authority to require this?
That 1 year requirement is for decommissioning or ceasing operations at a site, not for the site investigation that's triggered by municipal permit triggers. It's very specific to decommissioning and ceasing operations and foreclosure, sorry. And the authority to require that is actually it's written in the CSR now. That is one of the amendments. It says right into the contaminated sites regulation that you have 1 year to complete that work.
Okay, our next question. For multi-phase developments, will an approval in principle allow for redevelopment over more than 5 years?
It can. That's something that would have to be proposed as part of your application.
Okay, I've got 2 questions similarly related from Christopher here. What email address is used for submitting a remediation plan to the director? And what email address is used for submitting a release request?
So after February 1st, under the new process, we will be switching to that email address that's on the cover page of this webinar, the site ID at gov.bc.ca. We're still working out the details of where to submit everything, but I believe that's where release requests will be submitted, and the remediation plan that's being submitted to the director should just be included in your release request. That's considered submitting it to the director. You don't need to submit 2 separate things.
Okay, our next question is from Tom. Oh, okay. I'm sorry.
I was just going to say a release request is also submitted to the director. So the remediation plan and the release request are going to the same place. So they are submitted together.
Perfect. Question from Tom. For a site that has a Schedule 2 activity that was decommissioned or ceased operations prior to the Stage 13 amendments, does the site disclosure statement need to be submitted within 6 months of the Stage 13 amendments coming into effect or earlier, within 6 months of the decommission or operation cease? Would you like me to read that again, Kelly?
No, I think I got
Okay.
it. So a site is decommissioning or ceasing operations before the amendments come into effect. Basically, when does the site disclosure statement need to be submitted by? Right now, it says in this that the site profile must be submitted within 10 days of decommissioning. So if you are decommissioning before February 1st of 2021, then the current rules apply. So they should have already submitted a site profile under the current process.
Okay. And our next question. Could you please elaborate more on how it changes affect oil and gas sites or OGC remediation and reclamation manual? Do you have to submit anything new to the ministry?
So the changes affect oil and gas sites because we're removing any triggers that require submission of what's currently a site profile or site disclosure statements in the future. They don't need to be submitted directly to the commission. The commission no longer has a role of assessing and forwarding those documents like they do now. It also, the site investigation requirements in the CSR don't apply to oil and gas sites because they have their own regulations around investigating and remediating oil and gas contaminated sites. You don't have to submit anything new to the ministry. It's the same situation where you have to submit a form for decommissioning or ceasing operations. It's just submitting the site disclosure form. Instead of sending it to the commission, you send it to the ministry and then give a copy to the commission. So it's a fairly significant difference in that the commission doesn't have any responsibilities under EMA or the CSR for receiving and reviewing and forwarding these forms. They come, and there's one circumstance where it comes directly to the ministry and then just a copy is sent to the commission for their records.
Hi, Kelly, I believe I lost my audio connection there for a few minutes.
Okay, I was still talking about that same question, so we're just on to the next one from
Okay. So
Christopher.
Oh, thank you very much. Okay.
Yep.
Will a proponent be allowed to develop a site if off-site contamination is not delineated, but the off-site contamination can be demonstrated to be not affecting or unlikely to affect off-site receptors? The example was a stable plume.
This is something that requires a type of pre-approval, which is outside of the release process. That has to be obtained before any certification documents are obtained for the site. So I would say maybe, but you would have to prove why you shouldn't need to delineate off-site contamination. So generally speaking, it could be possible, but you have to go through all the steps to prove that to the ministry first before you can request a release notice or a certificate of compliance or whatever document you're looking for. We're, you know, it's preferable to not use release requests for these types of complex sites, to actually go through and get an approval in principle instead, or a certificate of compliance.
Okay, our next question is
Yep.
from Tad. When a Schedule 2 operator shuts down, they are required to submit a site disclosure statement and conduct investigations. What is being done to ensure operators of these types of activities know about this requirement if there is no permits happening at the same time?
That is something internally that the ministry is working on. about compliance for that type of thing. One of the main ways we find out about these sites is actually from municipalities who are, you know, they're in that municipality, they drive by that site every day and they see it being decommissioned, and we get a phone call or an email about it, which has been effective, you know, in the past, a good way to do it. But we don't have a plan that I can lay out for you today.
Okay, we have a question from Courtney. Can you please repeat the new site disclosure statement exemption for permitted hazardous waste facilities? What section of the CSR is that in?
It's not for hazardous waste facilities. It says waste management facilities. So I suppose that could include hazardous waste facilities. It's anything under a permit or operational certificate is exempted from the site investigation requirements for decommissioning or ceasing operations, because they have their own requirements under the operational certificate or permit for closure. Having said that, if once that site goes to be redeveloped, if they need a development permit, then it will trigger the site identification process at that point. It just doesn't kick in at the decommissioning phase. I don't know which section of the section in the new amendments, it's either 6.2 or 6.3, I believe, where that is found.
Okay, our next question comes from John. I'm sorry.
No, go ahead.
Once a release request is submitted with accompanying reports, is there a mandatory response timeline from the ministry?
No, there is not.
Okay. Next question. Marinas have been added to Schedule 2. Is that meant to include any boat parking or only where fueling or repairs occur?
I believe where fueling and repairs are occurring.
Okay. And our next question from Gary. Is it correct the site can be exempted if there is already a legal instrument such as a COC, comfort letter, approval in principle, or WMC permit or approval?
Not a comfort letter. That is not one of the options for having an exemption. It is currently an exemption that's been removed because there really is, it's not really appropriate. Those old comfort letters, the sites that were cleaned up that long ago they don't meet our current day requirements. And often it was just maybe soil that was remediated. They didn't necessarily even address groundwater, never mind other media. So comfort letters are definitely not an instrument that gets you exempted. So certificates of compliance, AIPs, and if you are a environmental management area, designated environmental management area, then you are exempted from the process. There's a waste management permit or approval. No, that's not an exemption from submitting a site disclosure statement.
And a question from Dave. Is a site disclosure statement triggered for residential development on residentially zoned properties that have former Schedule 2 uses?
Yes. So this, if it's known that there was a former Schedule 2 use on a site, it does not matter if the site is zoned residential. It matters what the actual uses were on the site.
Okay, moving right along. If it was stated for scenarios 4 and 5 releases, a remediation plan as defined in the CSR must be submitted to the director. Does that refer to the definitions section of the CSR? How much detail is required in the remediation plan?
I believe remediation plan is defined in the CSR definition section, yes. I can't recall off the top of my head if it is further defined elsewhere. I can look into that and get back to the person who asked that question.
Okay, thank you. Under the new proposed system, what is the anticipated turnaround time for a release?
We currently don't have anticipated turnaround times. We have started looking at those metrics, and as they become available, we will let people know what an expected time frame is. So until we have that data, there's not much I can say about it. But there is no sort of legislated time frame that we have to turn these around. It's similar to making an application for a certificate of compliance or an AIP. Those don't have timeframes that the ministry has to respond by either. So there's not really any difference. We receive applications and we respond to them in the order that we receive them.
Okay, we have a question from Andrew. Regarding the need for contamination to be present to obtain a scenario 4 or 5 release, there are sites where access or logistics prevent a full stage 2 PSI investigation, so that it may not be clear if there is contamination and it would not qualify for determination. If we can't get a determination or a scenario 4 or 5 release, is there another mechanism for proceeding with the redevelopment?
Well, currently it's true. There are cases where you may not have access to a certain area of the site because you need a demolition permit and you can't get that one because it's being held up as well. But that situation won't be the case anymore because demolition permits are not a trigger. So, if it's possible to demolish the building that's in your way, or if that's the case, then you can do that. Alternatively, if there is, I don't exactly know if there will be a change to how we deal with that right now, where if there's potential for contamination at your site, then we would typically process one of those scenario 4 and 5 release requests based on the fact that there's a potential for contamination to be found because you haven't been able to investigate a certain APEC for whatever the reason may be. I would say that it would be prudent to do everything you can to investigate as completely as possible before you try to come to the ministry for a release request in the future.
Okay, and a question from Suzanne. Could we please have a recording of this webinar? It would be very helpful to be able to listen to the presentation and the Q&A again.
I believe that is the intention. We'll be working on getting the presentation, hopefully the recording posted.
Okay, and another question from Bonnie. Potentially the iron and manganese footnotes 43 and 46 on the groundwater standard table were not updated to reflect the numbering changes on the Schedule 2 in the amended version posted November 2020. An example was mine tailings was changed from H14 to H12. Will this potential error be corrected prior to February 2021?
Oh, I couldn't answer that off the top of my head. I'll have to take a look and see whether that was changed or not.
Okay, and we have a question from...
Yep.
Okay, and another question from Tom. For a site that has a Schedule 2 activity that was decommissioned or ceased operations prior to the Stage 13 amendment and is located within a municipality that opted out of the site profile process, when does the site disclosure statement need to be submitted? Within 6 months of the stage amendments coming into effect or earlier?
Well, that's an interesting question. So it doesn't matter if you decommission a site that's within an opted out community because you still have to submit the site disclosure statement in that municipality or currently site profile. That's always been the case. The only thing that the municipality has opted out of is receiving site profiles for their permit applications. So the decommissioning trigger is directly to the ministry. You can't opt out of that. So if a site decommissions in an opted out community, they're still obligated to submit a site profile to the director within the 10 days. of decommissioning, which is the current requirement.
Good. And just as it turns 3 o'clock, we are at our very last question of the afternoon that's been submitted. It's from Suzanne. If a remediation plan is substantially changed, must a proponent request a new release to be eligible for a development or building permit?
I'm not really sure what that question means. Substantially changed from when? You only have to submit a remediation plan if you're requesting a release for a development or a building permit. So if it changes, if the remediation plan changes sometime along the way, there might be a condition in the release letter to submit the new remediation plan to the director, because there's requirements in those letters to inform the director if there's been any change, and also to provide annual statements that give a summary of the remediation sort of completed to date and things like that. So I think that's where you would provide the new remediation plan as part of the annual reporting.
And Kelly, we've had no further questions come in.
Perfect. Well, that was good timing. 3 o'clock, and we got through all the questions. So thanks everyone for joining the webinar. That was great. Lots of questions, and if there was a few there that I didn't know the answer to, so I will try and get back to the people who asked those questions. And if you have any other ones, please forward them to the site ID at gov.bc.ca email address, and I can get back to you. Thanks very much.